All right, it's time to look into what's trending in employment law. Lawyer, you're on the clock.
So this is going to be great today. Jim, you're going to help me tag team Lawyer on the Clock today, which I said may run the bulk of the episode here. And I have explained to our viewers and listeners ad nauseum about what Chevron deference is in the months and weeks leading up to the Supreme Court's decision. And I do think it was really interesting that the Supreme Court, this was really one of the last cases that it released in its term here. And of course, being the last one being released was the immunity case, as it affects the former president of the United States, President Trump, and other former presidents of the United States, or when they are former presidents. So that one will have some far-reaching consequences. But I really do want to focus on Chevron here. And people have heard me give my spiel on what Chevron is, but I'd love for them to hear another voice on this. So maybe you can set the stage of what took place about 40 years ago at the U.S. Supreme Court, and what exactly is Chevron deference?
Sure. So thanks again for having me on, Burt. I love coming on the program.
Our viewers love you.
So Chevron was a case decided in 1984 and involved Ronald Reagan's EPA, right, their Environmental Protection Agency. And when the decision came out, that sort of at that time helped what Reagan's EPA was doing, was what they were trying to regulate. Conservatives sort of applauded the decision, and so it was good for conservatives back then. And then others sort of said, and then this is just going to be another one of the boring Supreme Court decisions that we'll probably never hear from again. And so put a pin in that for just a second, and then I'll explain to you what they decided. So in Chevron, they decided when an agency is interpreting an act of Congress, a federal law that has some ambiguity, that courts should defer to that agency's interpretation. So in other words, courts would just look for a permissible interpretation that the agency took regarding that ambiguous statute, and not necessarily the best interpretation. So if I were sitting as the judge, I might say, well, that ambiguous statute, the way that the agency read it, I can think of a better way, or that they could read it, but the way they read it was permissible, so I will defer to them. And over the years, this really
So Jim, let me stop you there, and let me kind of put this in the context for our viewers and listeners today. So let's take the FMLA, for example, okay? And we all know that the Department of Labor enforces the FMLA.
Right.
And so the FMLA, the statute itself, is what, maybe a few pages long. It's actually, a fairly short statute.
Yep.
And so, we know that since 1993, when the FMLA came out, it is one of the most difficult pieces of federal legislation to understand. It's one of the most difficult pieces of federal legislation for employers to comply with. And so what the Department of Labor has done is they have issued regulations interpreting the FMLA. So remember, I said the FMLA, the statute itself, is just a few pages long, but we have hundreds of pages of FMLA regulations, right?
Right.
And so those are essentially the FMLA, or the Department of Labor's interpretations of what that statute means. Because when Congress passes these statutes, oftentimes there's not much to them. They sort of pass the framework of what they want the law to be, but they do not get into the specifics of how the statute should actually work, and how it should be enforced. And so then these agencies come up with their regulations, their rulemaking, et cetera, et cetera. And so in that context, we've got hundreds of pages of regulations that purport to interpret a statute that's just a few pages long. So what might this mean in that context?
Sure. So what it's going to mean is that what you described, Bert, is what I think the justices on the court, they would describe that, in the majority in the Loper Bright decision, which overturned the Chevron case, they might say, well, what Bert described is we've got agencies who are acting as legislators, right? That they're drafting the laws, and it's Congress's job to draft laws that are clear. And for what you described, Bert, Congress drafts these statutes that end up being ambiguous for a variety of reasons. One, sometimes they do it on purpose, that they don't really understand what they're doing, and they say, well, we'll let the agency decide. Sometimes it's just sort of like legislative fatigue, or they don't really know exactly what they're legislating. They might think that they've done a good job, but once the sort of rubber hits the road, you sort of figure out there's ambiguity. And then the other reason could be that, sort of like a legislative compromise, right? That they get the ball to that 1 yard line and they can't get it over, to get that statute passed, and then they figure out a way to do it, and then they leave it up to the agencies to do the rest.
So a famous quote from a former Speaker of the House: "We have to pass it to find out what's in it," is coming back to my memory.
Right. But so what this Loper Bright case is going to mean now for the DOL, and there's also, and we can get into this, there's all sorts of exceptions, carve out situations in which this isn't going to apply. Not every case is going to be a Chevron Loper Bright case, right? So I think it's important to set expectations here. But so generally, what this should mean is that over time, we're going to have courts determine when there's an ambiguous statute. They're going to determine the best interpretation of that statute, and they're not going to leave it to the agencies, which are in the executive branch, which are therefore political. They're not going to let the agencies interpret it over the years, where that interpretation can change depending on who's in the White House. So theoretically, we should be getting a clearer, more predictable law developing that's determined by the branch of government that's supposed to interpret the law, and that's the federal court. So over time, this should provide some clarity and some predictability for the business community as to what their obligations are. And it should put more power back in the hands of Congress to maybe roll up their sleeves a little bit more and write some clearer rules. And it should take away some, but not nearly all power from federal agencies who are unelected, government officials and unaccountable to the public.
So you bring up a really good point there. You kept focusing on time. You kept saying overtime, and not overtime, but over time. And I want to kind of stop there for a second, because we've talked on the program many times that, and I don't mean this literally, but I do mean it, to some extent. And that is that I've often said on the program, employers almost don't care what the law is. They just want it to stop changing every 4 to 8 years when we get a new presidential administration and the executive branch changes, and therefore the people who are leading all of these administrative agencies change. And that does, as you said, make those agencies very political in nature. And so, we on the employment law side, again, we kind of want the government to tell us what the law is and then stop changing it, so that we sort of don't get caught with our hand in the cookie jar doing what we thought was correct under one administration, and then the administration changes and now we're doing something completely illegal. Right. And so So what does that mean? You kept stressing over time. What do you think the short-term impact is going to be of Chevron being overturned? And what do you see as being sort of the timeline before we start to gain some certainty here?
Sure. So, I talked about setting expectations, and there's a lot of stuff, a lot of material, a lot of ink has already been spilled about this case so far. And I always tell people, especially when you're dealing with stuff like this coming out of DC, to pump the brakes and take a deep breath, right? I always use the example of when several years ago, this goes a little bit outside of labor and employment context, but there was a regulation passed in the Obama administration regulating the internet, and it was called the net neutrality rule. And then the Trump administration came in and got rid of it. And people were saying people are literally going to die because we no longer have this regulation. And I don't think anybody has died. So I always say it's a good example of like, take a deep breath, right? Read all this stuff that's out there, but then take a deep breath. So I think on the one hand, I talked about over time, we are seeing some immediate impacts about like cases that are already in the works. And we've had, the litigants file supplemental motions and say, hey, we got to take a look at this issue now because of Loper Bright. And so courts have sort of been responding to that and, sending it back down to the lower court to reconsider in light of Loper Bright and that sort of thing. So there is some immediate impact with cases that are happening right now. But in terms of the long-term impact, we've got to wait a little bit of a while to sort of see. Courts are going to test, litigants are going to test exactly what we've decided in Loper Bright about what gets deference and what doesn't, because Chief Justice Roberts was, careful to say that there are some instances or some regulations where Congress can specifically allow and authorize deference to the agencies. And he provided examples where Congress specifically says, we'll leave this up to the secretary of such and such an agency to determine, what's included in whatever we're trying to regulate here. So they've got to figure that sort of stuff out. They've got to really understand. The courts have to sort of, and plaintiffs and litigants and the business community are going to have to over time figure out what types of regulations they're talking about in Loper Bright, what types of actions they're talking about in Loper Bright, because it does not, it's not going to impact all agencies. State action, we deal with state law all the time. That's probably going to, it doesn't necessarily apply to state law or specifically apply to state law, but, you're going to see judges probably cite to Loper Bright if there's some sort of deference in state law. To sub-regulatory activity, it doesn't appear, and that's things like enforcement memoranda or FAQs that an agency might issue or guidance that an agency might issue. I don't think Loper Bright would apply to those, but there might be some challenge to that, right? There are some agencies like the NLRB. We talk a lot about the NLRB on this program, that they're already saying, Loper Bright's not going to apply to them at all because they've been around for so long, and the deference that courts have been giving the NLRB has been established well before even Chevron was decided in 1984. So there's all these different situations, all these different agencies, all these different types of agency action that's out there. That's not necessarily all going to fit neatly into the Loper Bright bucket, but agencies and plaintiffs are going to have to test that, and that's going to take time for it to go into courts, and you might have circuit splits and all this sort of stuff. So it's going to take time for the dust to settle.
Thank you once again for tuning in to This Week at Work. If you enjoy the show, please share it with your colleagues. Forward our invites. Share the link, aimea.org/thisweekatwork, or follow or subscribe wherever you get your news and entertainment, like LinkedIn, YouTube, Spotify, Apple Podcasts. We're everywhere you are. And you can be part of the show. Send your questions and comments anytime to info@thisweek.work. We'll see you next week, 7:30 a.m. Central Time, when we discuss what's happening this week at work.